Well, hey, this is Two Lawyers Talk Legacy. I am here with you. I'm Lisa Kay,
And I'm Sandy B.
and we're talking today about ways to avoid heir property. And you might be asking about that word, heir. What is heir property? Well, we're going to get into that. Sandy, this is something that we have to deal with a lot in our profession. You agree? At
Abs-
least these concepts of heir property.
I would say just about every probate case that I've had, for the most part, has been heir property issues.
You know, it's always something. So, what we're going to start with, just so you can get a little flavor, um, I think I want to start by defining uh, this term heir. So, we're going to go and pull up a slide here. I'm already sharing the screen, aren't I?
You're good?
Okay, I'm good. Okay, so yeah, this is a booklet from Farmland Access. Very interesting because this is a booklet for farmers, but it deals with heir property issues, the same kind of issues that Sandy and I deal with in our legal profession, dealing with probate. So a journal from 2022, but let me get to this definition, which I really like. I don't know how this little pop up to get rid of that, but it asks the question, what is heirs property? And I'm just going to read this blurb because you'll get a good sense of the issues from me reading this. Heirs property, sometimes known as family land, is property that has been transferred to multiple family members by inheritance, usually without a will. Remember that part. Typically, it's created when land is transferred from someone who dies without a will to that person's spouse, children, or other heirs who have a legal right to the property. Goes on to say, however, even if the person who died had a will, they may still create heirs property if they leave land to multiple heirs without making specific, uh, without specifying which heirs get which section of land. So that is it in a nutshell. It's going to come to light, I think, in a moment here as we begin to take a look at this video about the problem with heirs property when all of these people in the family, a lot of times, just own a piece of land and all the issues that can happen from it. Sandy, we have that queued up. I can.
We we do, but before we get into the video, I just want to give a little bit of a disclaimer because I know that we're giving legal information. So I'll just say that the views and opinions expressed on this show are those of the hosts and the guests and not reflective of any views and opinions of this platform, any other person or entities, and no information is intended as legal advice. The content of our program is just for educational and informational use only. So please, guys, be mindful. What we are sharing is really just to help you out. Please don't take our information as word is bond in your individual cases. Okay.
Very, very important. And thank you for that. And because Sandy absolutely did the right thing by, well, look, see, I lost my breath after all that. But by her stating that, it makes me think like, okay, Lisa, you missed the part. I need to say this. Besides the fact that we've already said, welcome to LearnBiz, the podcast, we want you to know that this is your go to destination for insightful conversations about legacy and entrepreneurship. This show is hosted by two lawyers, yours truly, Sandy and I, who are passionate about guiding you through the complexities of building a lasting legacy. So join us as we explore this intersection of legacy and entrepreneurship, sharing valuable insights and actionable advice along the way. Let's dive in and discover what it takes to leave a lasting impact in the world of real estate. Okay,
All right.
so that's where we are now.
We are here. So I'm going to cue up this video. This is an issue, heir property, in particular here in Florida, that is rampant. I mean, we have so many problems in the probate courts when someone passes away, and we're dealing with layers upon layers of people who passed away years ago. And now, 10, 20, 30 years later, we're dealing with a piece of property that's not owned by anybody that lives in the
Right.
house. So let's see what they have to say on this video.
Housing shortage continues in Florida tonight. We're going in depth on the struggle that so many Floridians continue to face after a loved one dies without a written will. Reporter Sophia Hernandez tonight taking a deep dive on this and the solutions just now coming to the surface.
I did not want to lose our home that we grew up in.
Natasha Abner has lived in the Richmond Heights community of Miami for over 50 years. She recently dealt with the heirs property issue after the passing of her grandfather. His home was left to her mother and disabled uncle.
Basically, what they had to do is actually quitclaim deed the property over to me in order for me to be able to save it. However, because there's a brother that was older than me who's deceased, we first had to make sure there were no children for him.
In Natasha's case, there weren't, but if there were, the house would have gone to them. It was a lengthy, confusing process she completed with the help of a lawyer, but in doing so, she noticed many of her neighbors were faced with the same thing.
So I want to stop here for a moment because, Lisa, you and I both know that this process becomes extremely lengthy because of the fact that people are not aware of their rights in this area, and
Yes.
they may not be aware that there are attorneys out here who are versed in this type of thing. And they also may not be aware that when you live in a home that is owned by someone else, it's not your home. It doesn't matter if you pay the taxes. It doesn't matter if you keep up the maintenance. It doesn't matter how much money you put in for renovations. None of that matters. What matters is what's on the title. And so
Right.
if you don't get that title ironed out, you are in for a whirlwind of work. Okay.
Absolutely.
So what do you think about this heir property situation here with her? Because they mentioned something about there was a brother, and there was some issue about questioning whether he had children.
Right. It sounded like had there were some other heirs that might have been entitled to her, like maybe one step above her, had the brother had surviving children, and but
Right.
he did not. So it was two siblings, and I guess it sounds like things would have flowed to his children, and she
Right.
would have had to deal with some heir property issues, but for the fact that he didn't have children. So I think that saved her in this situation. But a lot of
Absolutely.
times you end up owning property with people down the line in your family that you don't even know, don't have relationships with, and all of a sudden all of you guys are owning property together,
Right.
and it can become a nightmare.
I actually
It's-
had a case, what was it, a couple of years back. I think you and I spoke about this case where it was like the person passed away. I'm just going to give a random year. Let's say they passed away in 1980, the owner of the property.
Mhm.
And when they passed away, it would have technically gone to their children or to their spouse or whatever. Well, what
Right.
happened was is that person passed away, let's say 1980, and then the person that should have been the one to receive also passed away. And they had
Mm.
children. And then some of the children also passed away.
Oh
And so
boy.
that it would go to their children. We ended up in a situation where we were dealing with like the great, niece or nephew. I don't remember what it was exactly, but it was like several degrees of family. And then you would have like a daughter mixed in with like four other children that were like grandnieces or nephews or something like that.
Wow.
So it can get really dicey.
Sounds very convoluted and complex, and that's something that a lot of people can't even understand unless you put it down on paper in a genealogy tree just to be able to see how it all flows.
Yeah. And so it's very important, like this concept of heir property, that we're going through. It's a very important one because many of us will experience this because of lack of proper preparation. Many of
Right.
our family members are not going to put the necessary things in place to make sure that they are set when it comes to if they pass away, what happens to their property?
Exactly. I say think about it, take care of those things early and often, and then keep on living and only revisit them when you need to update and maybe make changes. But we should do estate planning. That's how the majority population has passed on wealth for generations. The quiet transference of wealth. We need to get into it, yo, you know?
You going back? You going back in
I'm
time,
going back. I
Lisa?
can't help it. I can't help it.
All right, let's see what else they got to say here.
That's majority of African American homes in this particular neighborhood. The majority of them have reverse mortgages. The majority of them, there are a lot of siblings, and they just don't have the knowledge of what can be done.
After
Look, I got to pause on this reverse mortgage thing, Lisa. I'm so through with this reverse mortgage foolishness. Like,
Yeah.
I do understand that some folks need to have reverse mortgages for whatever reason. The problem that I have is oftentimes they don't communicate with their family members. So what ends up happening is the person passes away and you have a reverse mortgage on the property. And now the family has to fight against this reverse mortgage to try, hopefully, to recover the property if they're not upside down. And you dealt with a case for me a while back on this where it was just like, it was a loss, basically, when you really think about it.
Yeah.
It wasn't a benefit to the family. So
It really wasn't. I mean, and you know, Sandy, we take cases as they come. If it's not a pretty scenario or situation, we take it as it is and we try to work the best results that we can as attorneys for our clients. But you know, these cases don't come very too pretty very often.
they really don't. And many times the end result of the case is not one that whoever it is that's trying to recover the property is going to be happy with. You know, they're
Absolutely.
sometimes end up in a true wash.
Yep. So it's something to definitely avoid.
All right,
her
let's see.
experience, Natasha went back to school to study real estate to learn just that. And it's not just her. There are nonprofits in Miami, like Legal Services of Greater Miami, that have about 40 cases that started within the last year due to this very issue.
And they run the gamut. So it can be anything from a person just saying, I have my home, I want to create a will so I can transfer my home. So there's that. But we also have cases where somebody's currently living in what is heirs property. And so those are the cases that are complicated.
And it's not just in Miami, but in Jacksonville. Lisk Jacksonville is a financial intermediary who works to keep wealth from seeping out of the underserved communities.
In Florida, we are particularly vulnerable as storms can hit a community at any time.
Unfortunately, when there's no end-of-life directive and you add in the sometimes complex relationships of families, it can be a challenge.
And, you know, that is particularly a issue in vulnerable communities because now those properties become vagrant properties. And again, when you're talking about institutional investors are savvy enough so that they can in turn, you know, pick off family members and buy their interest in the property.
It's a common practice throughout the state.
It's lack of knowledge, lack of, I'll say, financing. Credit is a big problem. So a lot of people are not aware, you know, that credit is important that in order to help them. So these developers come in, sometimes they'll say, okay, I'm going to help you with your credit and I'm going to help you do this. And before you know it, you've signed your home away.
At Lisk, they
Wow.
Man, that is facts on facts. That's
crazy.
facts on facts. You know, one of the main things that I've seen is when we start talking about things like gentrification, we start talking about corporations buying individual family homes.
Right.
We start talking about folks who are slipping in, whether it be wholesalers or investors, and they're basically giving families pennies and they're going to flip that purchase into thousands and thousands of dollars, all because you have, like they said, these very complicated relationships in families where instead of everybody in the family seeing the property as an asset that they can
Right.
benefit from, they're all fighting over I want, and then they end up with some chump change from a sale. In essence, if they had pooled together and said, you know what, let us buy it together, let us take, you know, pay off this reverse mortgage, let us try to get something collectively together, and then we sell it if we choose to.
That's
and
smart.
Make that money. That would have been smarter, but most are not really in that realm, and most don't understand why. Like, you know, this lady was talking about she went back to school so that she could learn this information.
Became a realtor. I'm impressed. She became a realtor. She said, "Look, I'm going to learn all about how this real estate is handled." And did you notice that legacy slips away from families through reverse mortgages?
True.
You lose real estate going down the family line because that mortgage company is going to take that property upon the death of the person who took out that reverse mortgage. That's generally how it goes.
Yep. I mean, you can lose out so much without realizing that there are some simple ways that you can work through these processes. And we're talking about loss of, farmland. We're talking about loss of vacant land. We're talking about loss of properties in urban areas, properties in, country areas, properties in areas that could have been developed
Yeah,
had there been a collective put together. And it all would have just taken some togetherness with the family.
that's
And
all
we're
it
just
is.
not
If
seeing
families
that.
be more sophisticated and work together, you might have a situation where 5 people own some lands. I've had a situation where 13, 14 people own one parcel of property, and there might be only 2 or 3 people that are taking care of the land, keeping
Right.
the grass cut to avoid code violations, making sure that the taxes are paid on the property, maintenance is upkeep. Only a few of them are taking those, responsibilities seriously.
Right.
And so that's the kind of situation where folks get tired and say, look, these folks are benefiting the price, the property is appraising in value. They're not paying their fair share. And then they want to sit back and enjoy the appreciated value of all of our hard work. That's the thing that makes people go out and say, I'm going to go force a sale of this property. And
Right.
nobody's going to have nothing.
Yeah.
It's
It's just
awful.
unfortunate. There's just so many things that could be done in the interim, and trying to work through the process if you get the proper representation and assistance. But again, many times people fall prey to folks who are going to come along and say, hey, got a deal for you. Here's a contract. Come and sign it. You don't need this property. It's just a headache. We can take care of it. Here, you can have some money, and that's all you really need. You don't need anything else. So it's
Absolutely. Let me mention one thing and then I'm going to get right to the 5 ways to avoid air property.
okay.
Florida has this new act. It's fairly new. It's from 2020. It's called the Uniform Partition of Heirs Property Act.
Okay.
And basically, this is an act that really tries to protect the heirs. When an investor comes up to the heirs and comes up to one of them and say, "Hey, there's 5 of you brothers and sisters. You guys each own 1/5. I'd love to go ahead and buy your 1/5 interest out today. I'm going to give you top dollar for your 1/5 interest and
Okay.
sell it to me." So that particular family member will then sell that interest out. The other four family members look around and realize that it's no longer 5 family members, it's 4 family members and an investor that owns the property. What happens, the investor says, look, I want the cash value of my interest now. I want it now. And nobody usually has the money like that or can get the loan. And so that investor then forces a sale of the entire estate just to get his little 20% out. That's what happens a lot of times. And so what also happens is strategic. The investors know that the folks can't come up with the money, so they end up offering each one of the heirs some, price to buy their interest.
Right.
Eventually investors end up with the entire property.
Yeah, that's a rough one. When you have somebody that is just popping up and basically intervening in family business, and that family member doesn't really think to themselves, this person's not in your best interest. Now, if you need to sell, that's one thing. But if you're selling because of lack of knowledge, lack of understanding, lack of awareness, that's a whole nother conversation.
That's a
That's a
whole
whole nother conversation.
So what the law does really quickly, this act, I'm sorry, what it does, it says the bill provides a right of first refusing, allowing the heirs property co-tenants to purchase the property interest of the other co-tenants seeking to partition before the property is divided or sold. And the bill requires a court to determine the fair market value of the property so people don't get taken either. So I think that that's a good thing to help protect heirs' property. Like the other heirs would have a right to have a say so in that property being sold off to an investor. Maybe they may want to buy it before something like that takes place.
Yeah, that's very possible. So
So
it's something to definitely consider.
yeah. So now let me get right to it. We're gonna now. Did we finish our video?
Let me see. There's just a little bit more. Let's see what else they
Okay.
say.
They're averaging about 100 cases a year, but there are roughly 12,000 in their area.
We have committed to resolving at least 2,700 in some of our most vulnerable communities, and that has an economic impact in and of itself of well over $169 million. That means,
Wow.
we are looking at putting $169 million back into our local economy. And that's because we know once we help people resolve their heirs cases, issues, they now are property taxpayers. They take care of their property. So it has an economic consequence in our community.
Recently, the state has made strides in trying to adopt parts of national standards into Florida's heirs property law.
If one of the part owners wants to force a partition sale, they have to first offer their share to the other owners. So if that, like say, investment entity now wanted to force that, first the other owners have to be given the opportunity to buy that person's share.
However, while it's a good protection, it may not save that family's home.
Problem is, in cases, in families that we see here, especially low-income families, those other family members may not have the money to buy that 1/3 share.
It's a fear that Abner has seen play out time and time again.
I feel like we're being shafted. I honestly, if I could say anything about it, we're just not given the fair chance to be here anymore.
It's why she and other local organizations are hoping that by going out into the community and teaching others of their rights and options, heirs property issues could be far and few. Sophia.
So we definitely have quite the issue when it comes to this heir property thing. There are so
It's
many
bad.
things.
Yeah.
It really is, and it shows that there are so many things that we need to do still.
Yep.
That we just need to take advantage of the opportunities and try to get it together.
Absolutely. So let's get right to it. There are lots of different things you can do as far as planning is concerned to try to avoid this situation. It does take some planning. So, one of the things you can do if you are making a will, you can limit the number of heirs or beneficiaries by law. If you don't make a will, you don't get any say so in that part. But at least if you make a will, what if you have 19 nieces and nephews and only 3 of them are responsible? Are you going to give that property to all 19 people, or are you going to give it to the 3 who are going to take care of it and likely to maintain it and keep it and pass it on as a legacy? We have to think like that.
We sitting at the dinner table. Everybody got to get a piece. They got to get a piece. They got to get a piece.
Right? Everybody's got a piece. So we got to remember that. And so that's number one. Number two, if the property is not legacy property, and we'll talk about that, then you can order that property be sold. Now, when I mean order, I'm talking about if you set up your estate planning document, a trust, or even in your will, you can say that upon my death, I want this property to be sold. You won't create heir property if you order the property to be sold. Or you might say, there's 5 folks that likely are to inherit this property from me. I'm going to give the property to this 1 or 2 responsible people, and everybody else will get a fractional interest of money, because you generally know who's going to be responsible. And then, Sandy, you got a point. You got to talk a comment on number 2.
It's I have a difficulty here because a lot of times people don't realize what devices that they need to use in order to set up this type of legacy property. They think that they could just quit claim deed, or they can just add someone's name to their property. So if they die, that person's there. And it's like, if it's not done properly, you can end up having a property where somebody passes and now you have half a property in probate and half a property that belongs to someone. people need to be careful with this, and they need to hire the proper professionals to do this so that it actually is legacy property and not, property that's going to be forced to be sold.
Mm-hmm.
But also, sometimes there is a need to sell, and hopefully
Yep.
you can iron out something in your planning to say, if there's a conflict or an issue, well, I want it to be sold and divided in this particular way.
Absolutely. And what we mean by if the property is not legacy property, generally legacy property is that property that, like the family home, that you want to be passed down from generation to generation. You want, everybody in the family line to live in that house as a part of the generational transfer. So if it's not that type of property, or maybe investment property might be the type of property that you might be willing to part with or sell, um, in order to avoid creating a heirship issue.
Yes.
All right. So number 3, consider probate.
Ugh.
Everybody hates probate. I know, right? That's the appropriate reaction that Sandy just gave. Ugh.
Yeah, don't consider
Everybody
it.
hates probate. And you wonder, Sandy, like, why in the heck would Lisa put this on the list? Well, the reason why, because at least if you live in granddaddy's house, if you go to probate court, you can get the title changed over into your name if you are the next in line to inherit it. Why keep living in granddad's house when the name is in the estate of John Doe, and that's granddad?
It's just, sometimes I think it's just laziness. Sometimes I think it's lack of funds. Sometimes I think it's lack of awareness. I think people sometimes believe, well, it's my granddad's house, so I can live in it. I just have to pay the bills and keep it up, and I can just live in it. But I'm like, when something important comes along, like let's say you want to refinance, if there's a mortgage, or let's say you want to sell, well, now you're going to have to go through the probate court process.
Right.
Because
Right.
you don't have the authority to do anything with the property, and be like, oh, well, that's my granddad. So you don't have authority. You're not the owner.
Exactly. Yeah. That's
Oh,
your
that's my wife. That's my husband. So
That's theirs. Not yours.
correct.
Legal.
And they're no longer, they're gone.
And they're gone. So only the courts can get involved at that point. So that's why I say
Absolutely.
number 3, you can consider probate to clear up the mess. Number 4, don't own any accounts in your own name. Get joint banking accounts, have joint deeds with right of survivorship. If you have these type of joint accounts, these things avoid probate. So I think everybody knows what a joint bank account is. You just don't own it by yourself. And then joint deeds are deeds again with rights of survivorship, such that if one person dies, that the ownership interests merge in the surviving owners. So that avoids probate.
Now, I will add one point to this, and this is
Okay.
something that I've experienced personally, and it's also something that I've dealt with tons of times with clients. While having these joint accounts is great and having the joint deeds is great, there also needs to be a plan for what happens when one person passes and now we just have one person on the property. That
True.
person needs to make sure that they have a plan for what happens next. So if I have a joint bank account, please understand, if I pass, the other person, it's now their account. There's nothing I'm going to be able to do at that point. So if I wanted my share to go to someone, we needed to have some kind of arrangement where the account has some kind of, contingency or something like that. Because otherwise, you need to have some separate account where you have a beneficiary and you can leave it to who you want. But the moment
Right.
you pass and you have a joint bank account, the other person is now the account owner. The
Right.
second thing is, when you have joint deeds, many times people have joint deeds and they're like, okay, someone passes and then they don't have a plan for what happens next. Well, you may need to do another deed where you now determine who gets the property next. And it's not just as simple as just adding your name. So please be careful of that. That's not what we're saying here. What we're saying is the proper planning will create a joint tenancy with right of survivorship properly. The proper
Mm-hmm.
planning will allow you to have joint banking accounts and being able to still have those funds transferred to the proper people based upon what your intentions are. Because, once you pass, that changes the situation. It's no longer joint. So now it could be probated if that second person also passes.
So it can get, as you can see, these layers can get complicated. It's like peeling an onion back. It gets a little bit more complex. It makes you want to cry a little bit more.
It's all about the paperwork now. It's all about the paperwork.
Yes, definitely about the paperwork. So looking now, going back to my list here, we have number 4 is you can create a trust. You've heard many times people talk about creating a trust to avoid probate. Many people create trust to do exactly that. Trust help you avoid probate court. And you can put your property in a trust, and the trust can own your real estate just like a person can own property and other assets. So can a trust.
And I'm going to add another disclaimer to that.
Okay.
When she said you can create a trust, she didn't mean you as in you. She meant you as in you through a licensed professional who
Attorney.
understands how to properly set up a trust, how to have you properly fund the trust, and understand that trusts are not for everybody. There is
True.
a purpose and a reason behind having a trust. And you need to determine what it is that you're trying to do before you go and say, oh, I just need to create a trust. A trust is not going to shield you from everything. It's not a force field. A trust is a document that allows some level of authority and control over your assets while both you're living and after you pass away. But it's not a force field. It will not shield you from creditors. It will not shield you from the IRS, the child support, the alimony, the mortgage. It's not going to shield you from these things, but it can create certain protections in the way that you want your legacy to happen. And it can create some structure and some authority in someone that you trust.
Absolutely. And they work beautifully. Someone called me, their relative died, the relative set a trust up, and the trustee, the successor trustee was the child of the deceased. And the question was, you mean to tell me I don't have to hire a lawyer? I'm like, no. I don't have to go to court? No. I don't even have to go inside a courtroom to transfer this property according to what the trust says. No, you do exactly follow the exact instructions of the trust, and you are carrying out legal responsibility that you've been assigned to do pursuant to the trustor. So I love it. People love trust once they see how easy they work. So it is a way to avoid probate. And I love your comments too, Sandy, on that. We got one more thing. This is just my bonus. And I'm not saying this is an exhaustive list. There are other ways, but these are some ways to consider. So my bonus way is use beneficiary designations on all your financial contracts. People have life insurance contracts and policies. They have other financial accounts, retirement benefits, you name it. You can designate who shall receive those proceeds and those funds upon death by signing beneficiary designations on all of those accounts. And that escapes probate.
Yes, it does. Now, I'm always going to add the extra because every time we say something escapes probate, we forget about the next level, which is one person's estate is going to escape probate. However, the person who now owns the money that's in the bank or whatever it is has to now do their planning to protect what they are receiving. So they now, if they're going to put that money in an account, needs to also now go and create beneficiary designations on their account. And there's also a way to do contingent beneficiaries so that you make sure that if something happens to you or something happens, sorry, not if something happens to you, if something happens to the person that you listed as a beneficiary, that you have a backup just in case.
Right. That very, very important. And you got to keep those things up and check and make sure and double check and make sure you have them all filled out the way they're supposed to. And you can protect yourself through that planning. So that's it. 5 ways to avoid heir property. Heir property generally is not a good thing, folks. Usually that property does not end up lasting. Something happens. It ends up getting sold. It ends up getting mismanaged. It's too many players in the game, and in particular, people of color, African Americans especially, have lost a ton of generational wealth since the end of slavery through things like heir property, because we haven't managed them well. So we've lost a lot of what our ancestors were able to accumulate.
Absolute. So this education that we're providing is essential in order for you to make the proper decisions when it comes to your legacy and your property. So we hope that you found the information that we're providing helpful. Just so that you know, the information today was provided by our law firm. So I'm going to start with Lisa K. Crawford, Esquire. She's a real estate broker and associate with URG, and you can contact her at 954-864-8950 for your real estate matters. And if you are looking for a probate attorney who has an understanding of probate real estate and heir property, you can also reach Lisa at 954-870-7600. She has her websites up here on the screen. Lisa K. Crawford sells homes for your real estate needs, and lisakcrawford.com for your probate and estate planning needs. This show is also sponsored by Spectrum Law Florida, your estate planning, guardianship, and probate attorney. You can reach them at 888-959-8264, or you can go to the website spectrumlawflorida.com. We also wanted to remind you that our LearnBiz Entrepreneur Journal is now available on Amazon. It's brought to you by your two attorneys who are talking legacy today. It is something that we created with an intention for entrepreneurs, as we both are attorney entrepreneurs, and it gives you a daily touch in order for you to build your business, grow your business, and identify things every single day that will help you make changes in your realm of entrepreneurship. So we hope that you will grab yourself a copy and take advantage of this opportunity. So,
Absolutely.
in closing, as we wrap up the show today, I want to thank you for tuning in to LearnBiz, the podcast. Please do not forget to like, comment, and subscribe to stay updated on all our latest episodes. For more conversations about legacy and entrepreneurship, you can also follow us on social media. And please remember, your legacy starts now. See you next time on LearnBiz, the podcast.
Bye bye.